वकील साहब, आप लोग बड़े फक्र के साथ कहते हैं कि साहब हम हर केस में फीस नहीं लेते हैं।
मैं नहीं कहता साहब। सर
सुनिए सुनिए, कीप योर माउथ शट, डोंट कंपेल मी टू यूज हार्श वर्ड्स, डोंट थिंक दैट यू हैव एनी राइट टू इंटरफेयर ड्यूरिंग द डिक्टेशन ऑफ द ऑर्डर, डोंट क्रॉस द लिमिट्स। यू सेड सेम थिंग इज मैं तो प्रो बोनो करता हूं, मैं किसी के लिए कोई मदद नहीं करता हूं। इफ यू आर ashamed of your words then you should not have spoken। मुझे मालूम था, इसलिए मैंने आपको ऑब्जेक्शन ओवररूल करने के बाद आपसे पूछा।
Indeed, my lords,
कोई बात
but
नहीं
I
सर,
was also prepared.
पार्डन सर।
My lords, I was also prepared that my lord may ask the very pertinent question also, my lords, that what is the case
मैंने
law?
सर ये चेक करने के लिए पूछा था कि आपने तैयारी की कि नहीं की।
Indeed, my lords.
पहले मैंने ऑब्जेक्शन ओवररूल कर दिया क्योंकि आई न्यू द जज।
My lords.
तो सेकंड
My
वाज द क्वेश्चन
lordship.
दैट द लॉयर।
Lordship
हां
on
बताइए
merits, my lords.
सर,
May I
व्हिच इज
address?
दैट ऑर्डर ऑफ द लोक अदालत?
P3, my lords. Annexure P3.
सो इट वाज विथड्रॉन बाय योर काउंसिल।
Yes, my lords. I did not authorize him. मैंने उसको बिल्कुल भी बात नहीं।
have you approached the bar council?
Yes, I have.
Which is that, sir?
Lordship, that is at annexure
Have you
P6.
deposited the requisite fee? Is it the method of filing a complaint? So what is the procedure, whether a requisite number of the copies of the complaint are to be filed along with the complaint, or ऐसा ही
My
एक,
lords,
and whether
he cannot.
sir please
he-
sir sir मुझे
जी
नहीं मालूम है, आप ही लोगों से तो पूछूंगा और किससे
जी
पूछूंगा।
सर।
What is the procedure for approaching the bar council?
My lords, there is a format in place to my knowledge. To my
फॉर्मेट
knowledge,
के साथ कुछ फीस भी है?
there is some requisite fees, and on affidavit, I think he has to
हाँ
submit
सर,
it.
तो बस सर पहले आप वो कर दीजिए, उसके बाद मैं आपको फाइल करने की लिबर्टी दे दूंगा।
Sir, he being a poor man, neither can he afford it.
कोई
My
बात नहीं
lord,
सर, अगर बार काउंसिल एक
जी
अधिवक्ताओं की संस्था होने पे अगर कहें कि
जी
हमें किसी की गरीबी से कोई मतलब नहीं, आपको तो फीस देनी पड़ेगी।
नहीं सर, वो
तो
बात
सुनिए
अपनी।
सुनिए 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 सुनिए, वो आपका प्रॉब्लम है।
नहीं
और
नहीं
अगर वो
सर
कहती है
सर
कि हमारे सुनो, और अगर वो कहती है कि हमारे पास फीस को वेव करने का अधिकार है, तो उस अधिकार के अनुसार आप आवेदन लगा दीजिए।
सर, he is a village person. He can
वकील
hardly afford to
साहब,
come to it.
वकील
जी सर।
साहब,
जी सर।
इससे ज्यादा बहुत कुछ सुनना चाहते हैं तो तैयार हो जाइए।
My lord, may give me 15 days time. I will file a
अरे
proper
फाइल इट
petition.
फ्रेश, आप
No, no,
प्रॉपरली।
my lord, he may not afford the second petition.
वकील
His
साहब,
his
आप
his
लोग
son
भी तो
died.
कभी,
Sir,
आप
his son
लोग
passed away. Sir, his son passed away. His young boy passed away, sir.
आप लोग
उसका
आप
उसका डेथ
लोग
क्लेम था। जी
वकील साहब, आप लोग बड़े फक्र के साथ कहते हैं कि साहब हम हर केस में फीस नहीं लेते हैं।
मैं नहीं कहता साहब। सर,
सुनिए सुनिए,
प्लीज डू नॉट जनरलाइज। सर,
आप
मैं
लोग
नहीं कहता।
कहते हैं कि हम
मैं
लोग
नहीं कहता सर।
सहृदय। अरे
सर, मैं
आप
नहीं कहता। सर, मैं
आपने
नहीं कहता। दिस इज
मत
प्रो
कहिए।
बोनो सर। सर, मैं नहीं कहता। सर, दिस
16627
इज प्रो बोनो।
2024।
हिज सन डाइड अवे।
Okay, sir, now allow me to,
इंडीड सर।
I am dismissing the petition with liberty to file afresh after approaching the bar council in a appropriate manner, sir. 16627. This is nothing, it is an eyewash, camouflaging और कुछ नहीं है।
My lord, that
16627
is on merit. If I may address it on
under
merits.
Article 226 of
My lord,
Constitution
may I address it?
filed seeking the
Sir, don't. Sir, मेरे को my contentions may be considered once. My lords, my contentions may be considered once.
then I will
My
not
lord,
grant you any liberty.
yes,
Right,
I bow down to that.
fine,
I bow down to that.
fine.
Once I start my arguments, my lord, there would be no turning back.
Yes, yes,
I
yes, I
will
should
face.
not interfere. Yes, you are right. आपने कल
Indeed.
का वीडियो देख लिया है सुप्रीम कोर्ट का, therefore you are also trying to step into the shoes of the same lawyer. No problem.
No, my lords, may I
No
argue my
problem,
case?
sir.
He is
Please
a very.
continue with your argument. Please continue with your argument.
My lords, his son died away. सर, आवेदन पत्र अंतर्गत लोक अदालत में आपसी राजीनामा व प्रकरण को वापस लेने बाबत महोदय यह कि उक्त प्रकरण आवेदक गण पक्षकारों के आपसी सहमति से प्रकरण को विचारण नहीं करना चाहते, इस कारण प्रकरण का विचारण नहीं चाहते हैं, इसलिए निराकरण कराना चाहते हैं। अतः माननीय न्यायालय से प्रार्थना है कि प्रकरण का आपसी सहमति के आधार पर लोक अदालत में समाप्त करने की कृपा करें। आवेदक द्वारा अभिभाषक। नहीं सर, इट डज नॉट स्पेसिफाई कि आवेदक क्रमांक 1 की तरफ से था या आवेदक क्रमांक 2 की तरफ से था। Even if I was assuming for a moment that somebody had authorized him or not, but ये किसकी तरफ से था ये भी क्लियर नहीं है।
सर आप उसका जिस्ट बता दीजिए।
Sir,
मेरे
sir, बता दे रहा हूँ.
को- आप
Sir,
चिंता
sir,
मत।
sir, it only says we have answered the question on the assumption that there is withdrawal in fact as well as in law. The question of referred to us would not arise if there is withdrawal in fact but not in law. My lord, my contention is that I never authorized him to withdraw, and my lord, the withdrawal is not a withdrawal in law. It is only a withdrawal in fact. There had to be a proper authorization, my lords. And the entire claim, I did not receive a single penny of compensation. The entire claim stood withdrawn, my lords. That is my contention, my lord.
16627/2024. Shri Dhruv Verma, counsel for the petitioner through video conferencing. It is submitted by counsel for the petitioner that the petitioner number one had lost her minor son and in a vehicular accident, and accordingly the petitioners filed a claim petition for grant of compensation to the tune of rupees 1,50,40,000. The petitioners never authorized their counsel to withdraw the claim petition. However, an application dated 11/5/2024 was filed for withdrawal of the claim petition. Not only this application was not signed by the petitioners, but it was not on the authorization by the petitioners, and therefore the application was filed by their counsel, thereby committing a serious professional misconduct. The Supreme Court in the case of R. Muthukrishnan versus Registrar High Court of Madras reported in 2019 has held that whether an advocate has committed a professional misconduct or not is within the exclusive domain of the Bar Council, be that whatever it may be. The counsel for the petitioner was given an opportunity that he may revive the petition after making a complaint against the council to the Bar Council in a proper format. Respectable member of the society, he is also not ready to file the second petition by bearing a meager amount of rupees 500, approximately rupees 500. He also submitted that he never helps out the litigants on financial side, be that whatever it may be.
And my lord, may author
Just a minute, Mr. Dhruv, now keep your mouth shut. Don't compel me to use harsh words. Initially, you said that you should be heard. I kept quiet. Don't think that you have any right to interfere during the dictation of the order. Don't cross the limits. You said same thing is मैं तो pro bono करता हूं, मैं किसी के लिए कोई मदद नहीं करता हूं. If you are ashamed of your words, then you should not have spoken. And if you are proud of that, allow me to write it down in the order. Right?
Right, sir.
You should have a courage that whatever is spoken should be written. And if it is written, then you should not feel ashamed of that. Fine. Accordingly, this court is of considered opinion that the petitioners have failed to make out a prima facie case for interfering with the order dated 11/5/2024, passed by Lok Adalat in MACC number 11/2023. Full stop. However, this court cannot lose sight of one fact. The petitioner number one has lost her son in a vehicular accident, and a claim petition for grant of 1,50,40,000 was filed. Was filed for grant of compensation to the tune of rupees 1,50,40,000. 1,50,40,000. Whether the withdrawal was on account of some out-of-court compromise or not is a part of the allegation as to whether the counsel for the petitioner has committed any professional misconduct or not, be that whatever it may be. Since the petitioner has leveled personal and serious allegations against the counsels who had appeared before the Lok Adalat, therefore it was necessary for her to implead them as a party, because without giving an opportunity to them, this court cannot record any findings against any of the lawyer. It is well established principle of law that when that nobody should be condemned without giving an opportunity of hearing. The Supreme Court in the case of Shivji wala judgment has held that in case if the allegations of malafide are made against a party who has not been implemented, then the same cannot be considered. Therefore, because of the legal hurdle which has been created by the counsel for the petitioner himself, because it was not expected from the petitioners to guide their counsel about the legal aspects, bracket close. This court is otherwise finding it difficult to adjudicate upon the submissions made by counsel for the petitioners. Under these circumstances, in order to protect the interest of the petitioners, this petition is dismissed with liberty to the petitioner to file a fresh petition after the professional misconduct of their counsel is proved before the bar council. It is made clear that in such a, with a force of liberty, the petition is dismissed.
I your question.